Good afternoon. Happy Labor Day. As you could tell from the terrible mic and the terrible background, I'm at the office today. I know it's Labor Day. I got some work done. I intend on getting a little bit more work done, but we'll see. Anyway, this morning I was watching a Stone Vet live stream. He's just tearing Frauditor Wrangler a brand new asshole. It's hilarious to watch. Um, Anyway, this fella, Broken System, Broken Trust, uh, sought me out in the live chat to ask me a question, and he asked me the same question twice. And I told him that it is a nonsensical question. Now, why would I tell him that it's a nonsensical question? Well, in order to really understand why it's a nonsensical question, I guess we would have to define some terms. The first term that we want to define is factual. What is a fact? I'm holding an earplug. I'm holding actually two earplugs. This earplug itself is not a fact. I just threw an earplug. That's a fact. A fact is an event, a happening. Something happened. What happened? Well, what happened was John threw an earplug. That's a fact. That's an assertion of a fact. Now, facts can either be true or false. You could say John threw an earplug. It's a true fact. You could say John threw an elephant. That's an untrue fact. Facts don't have to be true. But a fact is a happening. Somebody did something, whatever that is. John threw an earplug. John threw an elephant. What is evidence? Evidence is something that makes a fact more or less likely to be true. So when the finder of fact is trying to figure out what is a fact, what is a true fact, he's going to look at the evidence. And if, for example, you take this video in to the finder of fact, the judge or the jury, whoever it is, and you say, John threw an elephant, and you show the video of me throwing an earplug, the judge is going to say, wait a minute, that evidence makes the fact that John threw an elephant less likely. Now, if you brought the same video in and said, John threw an earplug, well, then the trier of fact would look at the evidence, the video, and say, that evidence makes it more likely that John, in fact, threw an earplug. That's what evidence is. Evidence is something that makes a fact more or less likely to have occurred. More or less likely to be true. What is jurisdiction? That's a sticky wicket. There are lots of kinds of jurisdiction. I'm not going to talk about in rem or quasi-in rem jurisdiction, and there may be even others that I'm not going to address, but I am going to address, I'll say, three kinds of jurisdiction. I'll break subject matter jurisdiction out just a tad. So there's territorial jurisdiction. That is the territorial limits of a state. Since we're talking about a state court, it's the territorial limits of a state where that state can write and enforce laws. Now, those territorial limits might be by agreement. Like with other states, it might be by an agreement with the federal government. Like when the state became a state, they might have had an agreement with the federal government. It might be subsequently limited by other things like federal enclaves. Like if the army establishes a army base in the middle of a state, the state loses territorial jurisdiction over that army base because the federal government now has sole exclusive territorial jurisdiction over that property. That's territorial jurisdiction. That's basically just where the state can make and enforce laws. Then there's subject matter jurisdiction, and that is the That is the authority of a court, in this case, it's a state court, to hear a particular case or controversy. Now, that's really wrapped up heavily with the state's ability to make and enforce laws within its territorial jurisdiction, because that's within the territorial jurisdiction is, generally speaking, with some minor exceptions, going to be where a state court can interpret the laws and adjudicate a case or controversy. There can be some exceptions, like, for example, if someone in Maine is doing some sort of an internet grift, defrauding people in California, well, then maybe California can make it a crime to do that. Maybe the state of California can enforce existing crimes, penal codes against that person in Maine, even though that person isn't in California. There's some loosey-goosiness with it. Generally speaking, the exceptions make sense. But going back to the narrower issue of subject matter jurisdiction, in California there is one court that has initial is the initial trier of fact for all cases and controversies, and that is the Superior Court. We used to have lower courts. California's done away with them. Other states maintain them, and they might even differentiate different courts. Like they might have like 4 or 5 different courts. They might have a magistrate's court. They might have a justice of the peace court, magistrate court, a county court, a district court, a city court. There might even be others that I'm just not aware of. But different states have different court systems. So, for example, let's say in a state that all I don't know, murder cases have to be brought in district court. Well, then a county court is not going to have subject matter jurisdiction over a murder case. Or for example, if they say, since we're talking about traffic infractions, that maybe it's the county court that has original subject matter jurisdiction over traffic infractions. So if you tried to bring in a justice of the peace court, well, the justice of the peace court wouldn't have subject matter jurisdiction. So it's subject matter jurisdiction is, does that particular court have the authority to hear that case? And generally speaking, that authority is delegated out by the state legislature and or the state constitution. We're going to set up these courts, and this court is going to get to hear these kinds of cases, this court's going to get to hear these kinds of cases, and this court's going to get to hear these kinds of cases. So does the court have subject matter jurisdiction? And then the final kind of jurisdiction that I'm going to talk about is personal jurisdiction. Personal jurisdiction just means that you have been placed on notice that there's a legal proceeding that has been brought against you. In a civil case, you are served with the summons and the complaint, and that places you on notice. Whether you show up or not, it doesn't matter. The court has personal jurisdiction over you. The court can enter a binding judgment against you once you've been served that summons and complaint. You're seeing that right now with Kate in the California case. Chili's trying to get a default against her, and the court's not having it, or he's trying to get a default judgment against her, and the court's not having it because, well, there's still other does in the case, etc. But if she was the only person left in that case, if the case had been dropped as to everybody else, Chili could proceed to try to get a default judgment against her. And the court would not say we lack personal jurisdiction because she's been served. How do we know she's been served? Because someone filed a proof of service of summons. And that's all it takes. I mean, theoretically, she could challenge it. She could file a motion saying, hey, especially appearing, I've not been served. Uh, that person never served me. And the court might set an evidentiary hearing where the process server would have to appear, yada, yada. Could happen. Don't know. Usually, if someone says if someone files a proof service of summons, usually that means that the person was served. So that's personal jurisdiction. In the case of a traffic ticket, the reason why they have you sign it is not to admit to liability or fault or anything like that, but it's to show that you've actually received the traffic ticket. It's evidence that the court has personal jurisdiction over you. If you don't sign it, what probably will end up happening is you'll get hauled in front of a judge, magistrate, whatever. And one of the ways that a court can get jurisdiction over you is if you appear in front of the court. So by making an appearance, involuntary as it is, the court's getting jurisdiction over you, personal jurisdiction. So, and finally, let's talk about what is a traffic ticket. A traffic ticket is it's essentially the same thing as a complaint or a petition. It is allegations that, if true, would allow the court to give the complaining party the resolution that complaining party wants. Like if I file a complaint, right, with the court, and then serve it, etc. What the complaint is it says these are the facts that I'm alleging, and if these facts are true, then the court should grant me monetary damages. The court should grant me injunctive relief. The court should grant me whatever. And so that's if true, right? And then the court proceeds from there. You've served them, then the people who've been served can engage in discovery, and by the time the trial comes, trial is the big deal. By the time trial comes, they can introduce evidence that will make the facts that you alleged in your complaint less likely to be true. I don't know why they would introduce evidence that would make the facts you allege in your complaint more likely to be true, but I guess that is also a possibility. So that's what a complaint does, and that's the same thing a traffic ticket is. A traffic ticket is just these are the allegations made by the state. The cop is just a conduit for the state at that point. And he says, if true, then this particular defendant should have a fine against them or whatever for violation of this particular vehicle code or transportation code or whatever code, right? So the allegation is sufficient to get it in front of the court. The court is gonna operate based on that allegation. If you want to challenge the allegation, you're gonna have to talk to an attorney in your state to see if there is some way to bring a motion to challenge jurisdiction. Probably in a traffic ticket sense, there probably isn't one. You're probably just gonna have to go to trial and present your evidence that the court lacks subject matter jurisdiction at trial. In my experience, generally speaking, subject matter jurisdiction is one of those things that just can't be waived. If the court doesn't have the power to adjudicate on an issue, the court can't waive that. The parties can't waive that. It's that way for federal courts. It's that way for California. I'm going to assume that other courts in other states, since we all borrow from English common law and those theories, and we're all somewhat pushed around by the United States Supreme Court and their findings that you can't waive subject matter jurisdiction, that I'm going to believe that most states also will not let you waive subject matter jurisdiction. So that means that right up to the moment where the court is right about to announce a verdict of innocent or guilty, subject matter jurisdiction is and was pending. And as soon as they make their adjudication, well, then you can theoretically appeal that lack of subject matter jurisdiction. You haven't waived it. Generally speaking, hashtag talk to an attorney in your state. So now we go back to this malformed question. Is a traffic ticket factual evidence of jurisdiction? Well, I don't know what factual evidence is. Evidence is something that is is something that makes a fact more or less likely to be true, but I don't know what factual evidence is. That doesn't make sense to me. And what kind of jurisdiction are we talking about? The only way a traffic ticket could really be evidence would be if you signed it. That would be evidence of personal jurisdiction. The court can theoretically make a ruling about you, presuming that it still has subject matter jurisdiction, but it has personal jurisdiction over you because you have received the notice that a legal proceeding against you has been initiated. That would be the only evidence of a fact that I think a traffic ticket would have on it. Everything else is just allegations. You signing it is just you saying, I've received this. You're not admitting to anything, any of the allegations contained in it. So, at least in California, hashtag talk to a local attorney, etc. So, it's just it's a hard question to answer. So maybe as far as personal jurisdiction, if you signed it, sure, it could be evidence of personal jurisdiction. But the rest, I don't believe it is evidence of subject matter jurisdiction. I don't believe it is evidence of territorial jurisdiction. Obviously, I don't think it's evidence of rem or quasi in rem jurisdiction either. So, or any other jurisdiction that I'm not particularly aware of. So anyway, I hope that answers your question, broken system, broken trust, and I hope you understand now why your question is nonsensical. And it took me 16 minutes to explain why a one-sentence question is nonsensical. That should tell you how nonsensical your question is. Thanks for watching, and have a great rest of your Labor Day weekend.